Welcome to this explainer. Right now, we're diving straight into a massive, hidden legal flaw that literally permanently voids spousal immigration applications at the very last stage. We're skipping the generic overviews today, Instead, we're going to act as a specialized analytical engine to focus strictly on the core legal facts, the implicit assumptions, and those non-obvious details that can completely unravel a seemingly flawless case. If you're looking at a delayed international spousal petition, well, this is the expert-level framework you absolutely need to understand the hidden mechanics at play.
So here's our roadmap. We'll hit the core legal prerequisites, look at how authorities actually verify documents, unpack the bureaucratic disconnect, dive into jurisdictional nuances, talk strategic expert intervention, and wrap up with litigation prerequisites. Let's get to it.
Section 1. The core legal prerequisite, or why chronological precision in family law is everything.
Okay, we have to start with the absolute foundational vulnerability of any spousal application that involves a prior marriage. I want you to ask yourself this: what non-obvious, single point of failure can completely unravel years of processing, thousands of dollars in fees, and just immense emotional investment right at the finish line? Most people naturally assume a denial happens because the government doesn't buy that the relationship is real. But honestly, more often than not, it's actually a deeply technical flaw in the foundational civil documents underpinning the entire petition. It's a structural failure, not a relationship one.
The real culprit is the lack of what experts call absolute legal finality. What does that mean? It means if a prior divorce wasn't absolutely 100% finalized according to the highly specific foreign law of that jurisdiction before the exact date of the new marriage, well, your new marriage is legally void for immigration purposes. There's no gray area here. Preliminary documents, local religious decrees, or paperwork that's just sitting on a desk waiting for a judge's final stamp, those are entirely insufficient. You literally must be legally, unconditionally free to remarry on the exact day you say "I do."
Chronology is the whole game here. It is a strict cause and effect timeline. Let's map out a solid example. Say a divorce is initiated on day 1, the decree is made absolutely final on day 365, and the new marriage ceremony happens on day 400. Boom, that works perfectly. But imagine the new marriage ceremony happens on day 300. Even if you're just stuck in a backlog waiting for that final decree paper to show up in the mail, doing that instantly and permanently nullifies the entire immigration application. The chronological order cannot be bent. It cannot be negotiated. It is absolute.
Moving on to Section 2, Mechanisms of Authority Verification and the strict government guidelines that govern them.
So you might be wondering, how do adjudicating authorities actually verify this chronological precision? Well, the harsh truth is that consular offices do not just take your word for it, and they frankly don't care what is culturally accepted in a specific village or region. They operate as a strict verification engine. They rely entirely on official internal reciprocity guidelines. These guidelines define exactly what constitutes a legally valid and finalized divorce in any given jurisdiction across the globe, and they are explicitly designed to prevent overlapping legal statuses.
And let me tell you, these guidelines are microscopic in their detail. They dictate the exact required document names. For instance, they might mandate a decree absolute and flat out reject a preliminary decree nisi. They specify the exact issuing authorities, the required official signatures, and even exact watermarked seals. There's literally zero room for interpretation. If your piece of paper doesn't perfectly match the strict criteria outlined in their internal databases for your specific region, it gets rejected. End of story.
Which brings us to Section 3, the bureaucratic disconnect, or the dangerous assumption of safety. Now, we've got to explore a massive, implicit assumption that traps so many applicants. There is a stark, almost dangerous disconnect between domestic immigration authorities and overseas consular offices. Domestic authorities will very often approve an initial petition based on a pretty surface-level procedural review of the documents. They basically check if a paper is there, implicitly assuming its underlying validity.
But consular offices? They have a completely different mandate. They meticulously verify the underlying foreign civil law at the very end of the process.
And this disconnect, it creates a massive, completely false sense of security. Just because a reviewing agency inside the country approved the initial petition, it in no way guarantees the final consular reviewer won't completely reject those exact same civil documents years later. You absolutely cannot rely on an initial, domestic approval as bulletproof evidence of absolute legal finality overseas. It's a totally different level of scrutiny.
Let's look at Section 4, Assessing Jurisdictional Nuance and Evolving Foreign Laws.
An anonymous expert report highlighted a really fascinating and frankly terrifying global shift. Foreign laws are not static, they evolve. For example, a jurisdiction might suddenly transition from a traditional local religious paper issuance to requiring electronic registry filing at a central courthouse. The catch here? Applicants must comply with the exact law that was active on the specific date of their event. Ignorance of a foreign statutory update that happens, say, a month before your wedding is absolutely not a valid legal defense.
And if you get caught on the wrong side of these evolving legal nuances, the cascading consequences are devastating. Because the underlying marriage is deemed legally invalid from day one, you essentially forfeit years of waiting in line. It instantly invalidates derivative applications too. Think about stepchildren who might literally age out of eligibility while you're waiting. Ultimately, it forces you to legally remarry under the correct procedures and start the entire, incredibly expensive petition process completely over from scratch. It is a total domino effect.
Section 5, Strategic Expert Intervention. Let's talk actionable mitigation.
So knowing all these hidden traps, what's your actual strategy when you hit an administrative delay or rejection? Here is the precise analytical risk framework you need to follow. Step 1. Completely pause any aggressive action. Stop pushing. Step 2. Procure independent legal counsel based in that specific foreign jurisdiction. Step 3. Rigorously validate your timeline against the precise law that existed on the exact date of your marriage. And step 4. Only when you're armed with that verified data do you decide whether to push for approval or bite the bullet, accept the flaw, and restart. There's a fundamental truth we have to acknowledge right here. General search engines are not going to save you. They simply cannot resolve complex international family law disputes. The statutes change way too frequently, and local implementation is incredibly nuanced. Neither the applicant nor a few hours of basic internet research can definitively answer localized jurisdictional questions. Relying on forum post or general assumptions is just a recipe for denial. You need grounded, objective legal analysis straight from the source.
Finally, Section 6, Litigation Prerequisites and Knowing Exactly Where You Stand.
We really need to look at the prerequisites for initiating litigation. A lot of applicants get incredibly frustrated by endless delays, and they immediately want to sue the government to force a decision. I get it. But as our analysis clearly shows, threatening a lawsuit without first verifying your absolute legal finality is a highly dangerous and incredibly costly gamble. Think about it. If you sue to force a decision, and it turns out your marriage was never legally valid to begin with because of a tiny timeline flaw, you have just paid thousands of dollars in federal court to force the government to hand you a definitive, permanent denial.
And that is exactly why Step 2 of our mitigation framework is so vital. You absolutely must hire an independent local expert. And notice I said independent. This must not be your original divorce attorney. Why? Because you need an objective set of eyes. The original attorney might have a vested interest in covering up a procedural mistake they made. This new expert must specialize exclusively in local family law and provide a formal, written legal opinion definitively proving you are legally free to marry on the exact date your new marriage occurred. To wrap up this explainer, I want to leave you with a final, really provocative thought so you can evaluate your own systemic risk. Is your foundational documentation truly, absolutely finalized under the strict letter of local law? Or was it just temporarily approved by a first-stage reviewer who maybe didn't look close enough? Answering that question with absolute analytical certainty is literally the only way to successfully navigate or litigate
this incredibly complex process. Thanks so much for joining me on this explainer today.